Thank you, Mr Acting Deputy President. Well, isn't the Senate lucky that we've got someone of Senator Ludlam's expertise here to help us with these bills? Nobody else apart from Senator Ludlam understands this. Everybody else has got it wrong, and only Senator Ludlam is correct. Now, because this is recorded on Hansard, can I just say to Hansard, this is said with irony, because I certainly don't believe it, but Senator Ludlam clearly does. Everybody else who's spent a lot of time and work in this is, according to Senator Ludlam, lazy. It's only Senator Ludlam that knows and understands these issues. Mr Acting Deputy President, this is a complex area, and I contribute to this bill as chairman of the Legal and Constitutional Affairs Legislation Committee, which looked at this in some detail, and I recognise the work that Senator Collins did, and it was quite considerable, and my colleague Senator O'Sullivan, who formed the basis of the intense investigation into this bill. Senator Ludlam got himself put on the committee so that he could contribute his expertise, but regrettably, when it came to the hearing, Senator Ludlam was nowhere to be seen. So he didn't bother to turn up and question witnesses, because he knows it all. He knew what their answers would be, but he chooses to come in here and accuse everyone else who spent a lot of time on this of being, quote, lazy, unquote. Now, Mr Acting Deputy President, I have confidence, first of all in my committee, but as well, clearly, in the Department of Communications, the Attorney-General's Department, who've put a lot of work into this very important area. Mr Acting Deputy President, online copyright infringement does pose a significant threat to the viability and success of Australia's creative industries. Infringement currently occurs on a large scale, and therefore rights holders need effective mechanisms to reduce the incentive for infringing practices. And the committee came to that view after investigation. I want to thank, as I say, the Senator Collins and Senator O'Sullivan, who carried the brunt of this work, but also can I recognise the Secretariat staff who, as always, put in an exemplary effort into considering all of these bills, of making sure every dot and cross of sentences and I's and T's is looked at in the submissions that are made, and assists the committee in the recommendations that the committee brings to the Parliament. Now, Mr Acting Deputy President, I take some pride in the fact that this is a committee which does not hesitate to recommend amendments to government legislation, or at times even to recommend against the bills. This is a committee which treats its work as a committee of Parliament very, very seriously. And this, again, in this particular reference, is the case. And I alert the Senate to the committee's report. And for anyone who wants to follow this issue, could I recommend the committee's report? Again, it's a balanced report. It sets out the key issues, the background, and then gives the committee's view on the bill and on recommendations that the committee might make. So anyone interested in the subject, have a good read of the report, and although it is a complex area, readers will know a little bit more about this very complex area. Mr Acting Deputy President, the committee did consider that section 115A5 of the bill may be too prescriptive in requiring the court to consider all the listed matters in every application for injunctive release. The committee took the view that the court should be able to exercise discretion in identifying the salient features of each matter on a case-by-case basis. And so the committee made the recommendation that the bill should be amended to provide for that. I'm delighted to say that in the other chamber, the government did accept the recommendation and amended the bill, and it passed with that amendment. So I'm delighted the government has looked at that. We do acknowledge as a committee the evidence given by the Department of Communications regarding VPNs, but the committee noted that the bill does not explicitly contemplate the introduction of injunctions against VPNs. The committee also notes that VPNs are likely to meet the primary purpose test that's proposed in section 115A(1)(a) to C. The committee would not, however, be reassured, or would be reassured if the government were to clarify the status of the VPNs in the explanatory memorandum, and I understand that the government has in fact done that. Mr Acting Deputy President, the committee also recommended that the explanatory memorandum be amended to specify that, quote, reasonable steps to disable access to an online location, end of quote, may include a requirement to post a landing page at the blocked online location, specifying the relevant online location had been blocked by order of a court and outlining details of the order. And that came about as a result of submissions made to the committee by those in the industry who pointed out that that was an important part of the process. The committee also noted that the bill was preceded by a regulatory impact statement but no formal cost-benefit analysis. And as such, the committee received no information that provided a comparison between the expected benefits to right holders and the potential cost to other parties. Although this did not affect the committee's ability to determine the merits of the proposed legislation, it does lead the committee to give consideration to the recommendation of the Internet Society of Australia, and they said in their submission that the government should review the effectiveness of the bill 1 year after its enactment. The review should include the number of sites and locations blocked, the number of sites and locations that continue to provide access to the alleged infringing material, the cost to CSPs of implementing requirements of the bill, and the practical effectiveness and ease of bypass of the methods used to implement blocking. So some of the matters raised by our expert Senator Ludlam, in his address previously, could be looked at and some actual data obtained. And so the committee recommended the government did conduct a formal review of the effectiveness of the Act to be completed 2 years after its enactment, and that's a recommendation which I think do think needs to make some sense, and it was mentioned by some of the submitters, and the committee accepts that view. There was a lot of evidence on the costs to various parties. The committee took the view that the question of costs should be a matter for the court to determine on a case-by-case basis. The committee notes that in the absence of malice, a non-party to proceedings would not normally be liable for costs, and as such the committee questions the utility of the proposed 115A(9), which in the opinion of the committee serves only to confuse the issue of cost. Now, there was evidence from, I think it was the Communications Alliance on this aspect. It was something the committee looked at quite closely. We did note the persuasive evidence of service providers to the effect that that a CSP bears no fault or liability for the infringement of copyright by its subscribers. Because of that, the CSP should not be required to contribute to the cost of the remedy. The committee was of the view that more clarity is required to assure or to reassure CSPs that the costs associated with site blocking will primarily be borne by those parties who are actually seeking the remedy. Finally, Mr Deputy President, the committee noted that compelling evidence regarding the need to indemnify a CSP for acts done or omitted to be done in compliance with court orders. The committee had some regard to the reasoning of Justice Perham in the Dallas Buyers Club versus IINet, but urges the government to provide greater clarity on the issue of the CSP indemnity from consequential actions, and accordingly the committee recommended that the explanatory memorandum be amended to provide greater clarity and guidance on the issue of service provider costs and liability subsequent to the service provider's compliance with court orders made under the proposed amendment to section 115A. And I understand the government has done that. And with those qualifications, Mr Acting Deputy President, the committee recommended that the bill be passed. Even if, according to Senator Ludlam, it's completely useless and of no benefit, but as I say, those who attended the hearing, those witnesses who gave evidence, the two departments and many other people, dare I say, as versed and as knowledgeable as Senator Ludlam, although from what I hear Senator Ludlam say, that wouldn't apply to anyone in the world, but I sort of go on the side of the vast majority of experts who agree with the committee, that the bill be passed. Again, in concluding, Mr Acting Deputy President, can I thank all of those who took the time to make a submission to the committee to make sure their views were considered before the matter came to Parliament. I thank those committee members who actually turned up, which I repeat wasn't Senator Ludlam, who knew so much that he didn't need to bother attending the committee. And can I again thank the Secretariat staff for, as usual, an excellent paper on the subject that encapsulates the committee's views. I urge the bill be passed.